ArbitralWomen is an organization that was set up with the thought that and the realization that arbitration, and in fact it's true for a lot of other spheres as well, of course, is a field that is essentially dominated or with participation of males. And so there was an organization that was set up so women would get together and help each other and promote each other and mentor each other. And it has been a very fruitful organization. And of course, as I mentioned yesterday, even though it is called ArbitralWomen and the aim is to counter the gender imbalance in the field, it is open to men. And every year there's actually an award for men who champion women's rights and who promote women. And there are discussions going on all around the world about this issue. And they're not just panel discussions about how do you take care of children or how do you balance your work-life balance, or which are usually the questions that you get to women. No, they're substantive discussions about law as well. This is the essence of ArbitralWomen. We should talk about the same thing. We're the same species at the end of the day. So I was particularly passionate about this event in Pakistan. Because even though I was born and raised up in France and did all my schooling outside of Pakistan and actually never lived here, my parents are Pakistani, and I even though I hold a French passport, I feel very much Pakistani, and it was always a desire of mine to come here and help Pakistani lawyers. And the first time I talked to Sajjad, I thought he's a wonderful person. You're so lucky to have people like Sajjad, who studied abroad and came back to Pakistan and is doing what he's doing. So honestly, kudos to him, and if we could all clap for him, because it's just The second thing is, when I met Sajjad, I was like, I'm sure there are other people like him. And I didn't see many at the time, but in fact there were so many. Not only were there people like him, but I noticed the energy from the younger generation. So that's the first thing we spotted, and that's why we launched the young group. The second thing I spotted is that a lot of this energy came from women. And that's where the ArbitralWomen thing got involved. So when we celebrated the 25th anniversary, I did the Paris celebration and also in London. I went to see some of the directors and I said, you know what, gender diversity is an issue, yes, but diversity is so much wider than that, okay? It's D with a big D. And I always talk about it, the immediate thought that comes is racial, ethnicity, diversity, of course. And, promoting arbitration throughout the world, so in a jurisdiction like Pakistan, of course, which is one thing. But also, and I think it's very important, and you could see it as a testimony of the whole event, is I think we have to think diversity in terms of generations as well, right? So people have 10 years, 15 years, 20 years, 60 years of work experience, or 5 years of experience, should sit at the same table, should discuss the same issues. This is the future of arbitration today. So, mixing the young generation, the older generation, women and men, Pakistanis, non-Pakistanis, I think this is what international arbitration is about. So we're extremely happy that we managed to do all of that with this event this year. We did a launch of the young group. We had supporting organizations throughout the world, from Asia, from the United States, from Europe, that supported this event in Pakistan. And thirdly, and importantly for me, we had ArbitralWomen who said, okay, we want to have a side event that is especially devoted for ArbitralWomen, so you can talk about ArbitralWomen. We have distributed a flyer about ArbitralWomen. Please look it up. Please look up online and sign up. For all the women out there, for all the non-women out there, look it up. It is an extremely valuable organization. If you sign up, ArbitralWomen will promote you. If you speak at an event, they will send it as a newsletter. If you want mentorship, they will link you up with a mentor. If you want to write in an article, they will publish it on their blog. If you want to attend the Untitled meetings in Vienna or in New York, they will find a place for you. If you want to participate in Vismut competitions, they will fund your competition, and they will encourage you to take part in those competitions. ArbitralWomen is just one example of a million other organizations that exist that are to help promote people in arbitration. This one is focused on women. So please, the women out there, I know you're brilliant, because all the women I've met here are extremely brilliant, and you have seen it from the panels yesterday. We made a deliberate effort in mixing people up. And of course, we didn't invite people just because they were women. They were there because they were brilliant. And you have seen them interact. So there is a place for you out there, so please sign up. And I realize I've taken a lot of time in the introduction, so I'm going to move on now. You're very privileged today to have, again, a pool of very talented women out there who are going to be discussing a topic that I think is very timely in Pakistan and actually everywhere in the world, which is myths versus reality in arbitration. If you open the news, you go on Google right now, anyone, I dare you, just put arbitration, you can put evil in the same sentence. Probably a million articles are going to pop up, right? Arbitration is evil, it's arbitration is the land of corporation, arbitration happens only before secret tribunals, arbitration is biased against states, all of these things that we keep hearing, right? So it keeps happening. I dare to say, use the expression used by a very famous person I'm not going to name that is fake news sometimes. It kind of keeps happening and over again. And I think it is high time.
Who could that be?
Who could that be? I don't know. But I think it's important to take, we're lawyers, right? So everything is about taking the facts, taking a proposition, and talking it through. So that's what we're going to do today. We're going to take a sentence, a myth, and then we're going to debunk that myth or not. So we're going to open it for discussion. And here to do that with us is, so we have immediately starting on my left, we have Maria Farooq. We're extremely grateful for Maria for being here. She's a senior associate at Access Law Chambers in Lahore. She's an advocate of the High Court. She's well known for her power sector dispute expertise, and she has extensive international commercial arbitration experience involving both ICC and LCIA roles. Give it up. We also have Maham, who's next to Maria, who also is an exceptional lady out there, so thank you so much for coming. We're extremely grateful for her participation. Maham Naveed is a consultant to the AG office. And in fact, if I may say, yesterday we had a lot of her colleagues that were present and participating, and we were extremely grateful for the AG to participate in this event. She's a member of the New York Bar, and she holds an LLM with a focus in private and public international law. She has worked as a trainee in leading international arbitration practices, including Sherman & Sterling in Paris, before joining the AG office. And she's one of the few female next-generation lawyers in Pakistan with specific focus in international arbitration. So give it up for Maham. Next to her, we have Manoj Malik, who I already introduced yesterday, but I will do again, because even though she does not need an introduction, I think it is important to remember who Mahnaz is and what she has done. Mahnaz is a barrister at 20 Essex Street in London. She is a barrister and an arbitrator and has acted as counsel on behalf of both investors and states in several investment and commercial disputes, including Pakistan, including against, I understand, in a case where Sara is opposite counsel. Mahnaz, there's a lot of things about Mahnaz that are extremely, commendable. But one thing I think, and I will say again, from Arbitral Woman perspective, is that she has been appointed, she's been the youngest ever appointed arbitrator in an exit annulment committee, which is just like the crème de la crème, like exit arbitrators, first of all, is very tough to get out there. Exit annulment committee is even like, the elite of the elite. And she was the youngest one to be appointed. And so, as you can see, she's a woman and she's Pakistani. So this is a really, really big deal. So we have a great privilege of having her. Sara, who also introduced yesterday, but also is an amazing lawyer, also an amazing person. I've been so privileged to have get to know her in London. She is the partner and head of the investor state dispute resolution practice at Addleshaw Goddard. who is one of our generous sponsors today. She's currently acting as lead counsel, like I mentioned, for a case in Pakistan involving the OIC treaty. But generally speaking, she's very active in arbitration, and she has tremendous experience in both commercial and investment arbitration and the major institutional rules. And she also sits as an arbitrator. Please, again, a round of applause for Sara to be here today. And last, certainly not least, we have Aneesa Agha, who is, sorry, I don't have your profile written here. I completely forgot to put it in my sheet, but she's practicing in Lahore at, can you just remember, just so I don't mispronounce the name of the firm?
Raja Muhammad Akram.
Raja Muhammad. And Aneesa has also tremendous experience in both, in commercial arbitration, litigation, transaction, and also in climate change disputes, which we mentioned yesterday. And we're extremely lucky to have her participate in the event today. So give it up for Aneesa. I'm just going to move over there. Sorry for the movement. Just better for the discussion. Yeah, and thank you for all the men participating, like Mahnaz noticed. This is exactly what we wanted, so it's great. So without further ado, we're going to start our discussion today. First point that we hear a lot about arbitration is that arbitration is more expensive than litigation, and it takes longer than litigation. And to address that comment, I'm going to have Farooq.
Okay, good afternoon, everyone. Actually, good morning. But I want to sort of go first with the domestic law and the domestic context of arbitrations. Because arbitrations are generally seen as an alternative to litigation, there is a perception that they are less expensive and less time consuming. Unfortunately, in Pakistan, they may well be less costly, but they're definitely as time-consuming, if not more, when you compare it with our domestic litigation, which would primarily be the civil suits that are instituted in the courts of Pakistan. The reason for that is that the arbitrations, which are the domestic arbitrations, are governed by the domestic law, that is the Arbitration Act 1940. It is, as Mahnaz and I were discussing earlier, to say an outdated law. And just to quote out of one judgment, which was actually given out in 1981, a judge of the Indian Supreme Court, at that particular point in time, India also had the same act, which has now been repealed, stated that the way in which the proceedings under the Arbitration Act are conducted and without an exception challenged in the courts has made lawyers laugh and legal philosophers weep. As per my experience, it has also made lawyers weep. So the reason why the act is outdated, so to say, is that it doesn't provide any time limits on the way the proceedings are to be conducted. It doesn't have any extensive guidelines on who should be appointed as an arbitrator. Moreover, it doesn't provide any sort of mechanism for costs that are to be awarded in terms of the length of proceedings. The only time limit that the Act does provide is that for the arbitrator to give an award, which is 3 to 4 months, and by conduct of parties, that particular time period can be extended and has in fact been extended. So within this mechanism, what happens in the domestic scenario is that the arbitrators that are appointed are mostly, actually, if not all, retired judges of either the High Court or the Supreme Court, which are mostly men. And they try to conduct the proceedings in a way which is extremely similar to that as of a civil suit. There are no procedural hearings. So in the international context, if you're looking at an ICC arbitration or an LCI arbitration, you would first begin with the procedural hearing where a procedural timetable is set out. And both the parties or more are aware of what the deadlines for the submissions are and when the hearing is going to happen. In the Pakistan context, this is very, very rare. It's only recently in a local arbitration that I've been involved in that we have seen a proper procedural hearing. We have yet to see if that timetable is followed. So because a procedural timetable, a procedural calendar is not set, the parties sort of just go on an ad hoc manner and they make their submissions, and once those submissions are done, then evidence is led. So there's a separate evidentiary stage, which is why you have a longer proceeding as compared to that of, let's say, an international context. Another issue there is the fact that the parties have little incentive to agree on an arbitrator. So even before the arbitration starts, the parties keep sort of fighting with each other as to who would be appointed as an arbitrator. The result of that is that many applications are made under the Arbitration Act, Section 20 to be specific, for the court to appoint an arbitrator. So even before an arbitration is started, usually we see that recourse is made to the courts. And then I've sort of explained how the proceedings go. And then you come to the end of the arbitration and you come to the award. So finally, let's say after years, if an award has been given, what happens? In the Pakistani context, what happens is that your award will not have a legal effect unless it is made rule of court, which means you have to submit the award to the court, and the court will then have to give it legal effect. Now, from that point onwards, there are a number of years that would be taken for the award to have a legal effect. It would go to the lower courts, there would be objections that would be filed, there would be proceedings conducted, and if it is made an award a rule of court, you still have the forum for appellate proceedings, and you can go to the High Court. So just to give you an idea, an arbitration that I was involved in, the award was given in 2014. It was made rule of court in 2018. So it's just 4 years off from when the award is given to when it's made rule of court. It was challenged in the High Court. It took a year and a half for the challenge to be successful, which it was. And what was the decision? The decision was that the arbitration have not been conducted in accordance with the Arbitration Act, so you restart the arbitration. So we're essentially now, we're setting up the procedural calendar. So you've looked 4.5 years have passed, and the arbitration is going to start again. It is definitely less costly as compared to, let's say, litigation, or maybe equally costly, but the time limit or the time effect is a complete myth in domestic arbitrations. Very quickly, talking about international arbitrations, I'm aware there's a time limit. When you look at the international arbitration context, and I would want to keep it specific to Pakistan, is that you have institutional rules in place, and you have the advantages of there being structure to that. You have committees from which arbitrators can be selected, and you can then, it's easier to appoint arbitrators. But the disadvantage to that is that it may very well be less time consuming, especially in the commercial arbitration context. We finished 2 arbitrations in 1.5 years, which is, I think, good time period. It is more expensive for the Pakistani parties. There is a consistent issue of our exchange rate. We have to make payments in foreign currencies. So even the most basic things of getting an ICC hearing room booked, my colleague and I have tried to figure out what is going to be the most cost-effective method, because we're representing a Pakistani client and we have to make payments in euros. And there is this whole issue of trying to reduce the costs as much. So currently, if you're looking at certain institutions, that sort of framework is not best suited to Pakistan in terms of the costs. And I think we can open it for discussion in terms of what could be the proposed solution, so everybody else can sort of give their input.
I understand that there is a problem with the 1940 Act. So if we're talking about Pakistani parties arbitrating disputes right now. So if 2 Pakistani parties arbitrate under a domestic arbitration, you've got the problems with the 1940 Act. I understand, and I'm reliably informed, that the international award enforcement has improved tremendously, and there is good legislation supporting that. And one of the ideas we were canvassing is, can 2 Pakistani parties do an international arbitration seated outside Pakistan, and then use the more streamlined international arbitration enforcement method? And one of the issues there is the cost. If you go to ICC or LCIA, then obviously the costs are very high. But equally, there are many other regional organizations, including a very fancy one in Mauritius. I'm not sure how good it is, but I'm sure the beaches are, around as well. And maybe it's a question of shopping around and then seeing whether you can make your arbitration international and then use a more streamlined track. It's just really a thought that we were canvassing earlier, and very keen to hear other people's views. The other issue that has come up is ad hoc arbitrations. I find ad hoc arbitrations a bit chaotic, but quite cheap. You just need one arbitrator. You could pick up non-Pakistani, shop around. I can think of plenty around this table, and you could do that. And there you've got an international arbitration seated in London, because you don't really need an institution, but yes, it helps with enforcement. So these are my sort of two thoughts.
Yeah, so just to sort of conclude, I think what Mahnaz has suggested is a very reasonable and optimistic and good alternative, because if we look at other institutions, or as you suggested, an ad hoc arbitral system, I think in the Pakistani context, given the issues with time in the local Arbitration Act and the issues with cost in the international context, this is an alternative that we should really look into. So I think, thank you very much for that suggestion.
Thank you both. And just to a couple of words on the regional shopping that you have access to. I mean, yes, of course, there's a Mauritius arbitration, but yesterday you had institutions from Asia that were present, and Hong Kong, but Dubai is also. I mean, if I understand correctly, everyone is going on weekends in Dubai, and it's just 3 hours away, and it's an extension of Pakistan. Dubai has an institutional center that's extremely popular. Singapore is of course, Singapore is one. There are
choose all the beaches.
Exactly. Bali as well, if you want to make a vacation. But I think the point is, and there is a little confusion in people's mind as to when you choose an institution, and ad hoc as well, is that it's black and white. I think if you go ad hoc, you could still ask for an institution for support as an appointing authority. So yesterday we had Ruba had joined from the PCA, and I don't know if many of you participated to that panel, but she explained that the Permanent Court of Arbitration has a very important role in appointing arbitrators, and in fact, if I'm not mistaken, is that the procedure under the OIC treaty, the Organization of Islamic Conference? I mean, that's one of the possibilities. I think if you refer to the UNCITRAL rules, which are the Rolls Royce of ad hoc rules, if you don't want to make your own rules, then you can refer to the UNCITRAL rules. The procedure is at some point, if the parties don't agree on the appointment of an arbitrator, the PCA can come in and appoint the arbitrator. But if you don't want to go there, you can also refer to an institution to appoint arbitration and arbitrators. And you have your very own institution here too, which I think we should mention, which can hold hearings. If the both parties are Pakistanis, then why not hold a hearing here? And you don't have to pay in euros fees for a very fancy arbitration center in Paris and flights to Paris. So this is just of course.
So in relation to Mahnaz's question, what do two Pakistani parties do when they entered into a contract? So what we've seen is that clients usually want to avoid domestic arbitration because they want to avoid going to the civil courts. That's not a problem in Karachi, especially if the clients are big companies, then the claim is likely to be an amount where you can go directly to the High Court. So one of the ways, which is not in a way promoting arbitration, but one of the ways is you just give exclusive jurisdiction. We've seen this a lot in clients based in Punjab or other parts of Pakistan. You give exclusive jurisdiction to the courts of Karachi, and at that time the claim, if it arises and a dispute arises, then you just go directly to the High Court. And that's why I think Maria was saying the enforcement of arbitral awards, that's a much better record in terms of enforcement of domestic awards. And that's primarily because under the 2011 Act, you go directly to the High Court.
I'll just add 2 quick points. One I thought was really good on Manoj made about ad hoc. My preference is also usually institutional, but ad hoc can be quite cost effective. Another institution that gives appointment services is the CIIARB, the Chartered Institute of Arbitrators. They have it's called the DAS, the Dispute Appointment Services, and it's very inexpensive. And there is a charter, there is an organization within Pakistan of the Chartered Institute of Arbitrators, and that can be an effective way of getting a good arbitrator, having some oversight. If you're a member, if you're a fellow of the Chartered Institute, you have to abide by certain ethical and regulatory conduct, and so they are able to police the arbitration to some extent. And the other point is, CIICA hasn't been mentioned, but the largest number of parties to CIICA are now Indian parties who are trying to get out of Indian courts. It's such an expensive, time-consuming.
Singapore.
Yeah. The Singapore International Arbitration. So the majority of their caseload is now Indian parties who don't want to be in the 10-year to 20-year process of litigating in Indian court. So that's another option, and they do administer a lot smaller cases as well.
Can I just ask a question, if I may? Sorry, I'm intruding, but can CIICA, and this is really a question to Rana, can CIICA administer an arbitration seated outside of Pakistan? So let's say I'm two Pakistani parties. I refer to the CIICA rules and ask you to administer it as an institution, but it's seated in London. So if the parties misbehave, you always have the English courts to go to, because that's the seated arbitration, but you are providing the institutional services.
Just like it's like any other international arbitration institution, so CIICA has that option. So the default is that the seat for arbitration would be Lahore, unless parties choose otherwise. So of course you could still choose another city, London, Paris, Singapore, Dubai. It's entirely the party's decision. And I think that might make more sense, because then the award would actually truly be considered an international arbitration award. And I think I might also add about this interplay between domestic and international arbitration. In the past there is jurisprudence, unfortunately, whereby the Supreme Court has held that the nationality of the award is determined by the governing law, which is ridiculous. With due respect to the courts, because generally it's the seat of arbitration that determines nationality. So, but if they want to play it like that, we could do the same. So we could seat an arbitration in Pakistan and have the governing law as, let's say, UK law, and call it a foreign award, right? So that if that is jurisprudence, you could use it to your advantage, although it doesn't really make sense, but that's also an option. But yeah, to answer your question, yes, any arbitration that CIICA administers could be seated outside of Pakistan as well.
Okay, thank you very much. We're going to move on to one of the second things that we hear a lot about, so not only in the Pakistani news, but also generally speaking, actually everywhere in the world, right? If you open the Financial Times or the New York Times, I have heard this. Arbitration happens behind closed doors, and it is always before secret tribunals. We hear that over and over again. I've heard it in France. I've heard it from the mouth of a representative of the EU. It comes a lot, the European Union. So, Sara, can you please talk us through this myth, if it is one?
And this myth, I think we have to distinguish between commercial arbitration and investor-state arbitration. Commercial arbitration is typically confidential, and parties want it to be confidential. So Queen Mary and the Whiten case every year do a study of International Arbitration Council and find out what parties want, what the trends are. And 87% of participants find confidentiality in commercial arbitration a huge advantage, and they want it to remain confidential. So they want an opt-out provision for confidentiality rather than opt-in. And this is largely because businesses want to continue doing business and not having their dirty laundry out in the press. And so confidentiality has always been, and I think should continue to be, a key advantage of international commercial arbitration. It's very different in the context of investor-state disputes. And unfortunately, I think what has happened is there's really a PR crisis in relation to ISDS. As Sadia mentioned, if you Google ISDS, you'll hear all of these secret tribunals deciding these, behind closed doors. Whoever has sat in an ICSID hearing will find that it doesn't grab one's attention for too long. It's actually quite boring, most of them, and that's actually borne out something I'll talk about a little bit later. But there's really nothing inherently confidential about the ISDS process, and what happened is the confidentiality that is part of international commercial arbitration was presumed to overlay the ISDS system, but there's nothing about transparency in exit arbitration that's required. So it can be as transparent as the parties want it to be. So the parties, for example, can agree to publish their pleadings, to publish the awards. They can agree to greater transparency by allowing the public access to exit hearings. So there's really nothing inherently confidential about the ISDS proceedings. And in my experience, typically it is the investor that wishes for the proceedings to be public and transparent as a means of shedding light on the untoward behavior of the state. So it's usually the investor who wants transparency, and typically it's the state who doesn't want transparency. But that obviously and sometimes there's very good reason for that. It might affect the host state's politics. It might cause an uprising, especially if it's about a sensitive issue like public health or the environment. But typically speaking, it's investors and not states who want transparency. And perhaps the best example of this is the Mauritius Convention on Transparency. So that convention aims to promote more widespread application of the 2013 UNCITRAL rules, the UNCITRAL transparency rules, which are a set of procedural rules dealing with, among other things, disclosure of case-related documents, public access to hearings, and submissions of amicus briefings for non-disputing states. And with a single stroke of a pen, any state can sign up to the Mauritius Convention, and as long as both the two disputing states that are at issue in the proceedings have signed the convention, then these far-reaching UNCITRAL transparency rules will apply. Now, were it to be widely adopted, and if states were to actually sign on to and ratify this treaty, then ISDS proceedings would be much more transparent. They would be totally transparent. But the uptake on that convention has been incredibly small. So there's only 5 states that have ratified it: Cameroon, Canada, Gambia, Mauritius, and Switzerland. So, it's out there. It can easily be adopted. And in fact, it can be adopted on an ad hoc basis, but actually there's no uptake. So I think this crisis about transparency perhaps is much to do about nothing, because actually the states don't appear to want it. And again, I know I'm bringing in perhaps a more a varied perspective on what's actually at play, but actually, and I think we'll talk about this a little bit later, transparency is there if state parties want it. But so far, they haven't had an uptake on it. And I think the best example of that, there's a BSGR case versus Guinea. And that case had everything that could possibly, it was like a Hollywood movie. There was corruption, there was scandal, there was, famous people who had done, perhaps corrupt and untoward things. So you'd think this would be a real grabber. And in that case, Guinea decided and agreed with the party, BSGR, that everything could be transparent. So they live streamed these ICSID proceedings. And it's interesting because despite all this criticism and everything should be transparent, almost nobody watched those. They're available on YouTube. You can stream them live. And there were like 200 hits. And that's not even people who, I'm a mother to 3, and my kids, it's a big thing to make slime and to have slime parties. And it's like, if you Google making slime, you get hits of, 20 million, right? And then 200 people looked at this, and that's not even looked and actually sat through it and watched it. It's just like clicked on it. And one of them was me to conduct the research for this. So actually, no one really...
The rest was your family?
Yeah, the rest was my family, and yeah, exactly. So, just to kind of underscore the point that it can be transparent. I personally think it should be transparent, because by and large, and Mahnaz can also speak to this, these ICSID proceedings are very fair. They're kind of, they're boring. Sometimes the arbitrators fall asleep in them. That's how boring they can become. And so it is something that can and should be transparent, but we really need the states to demand that, which they can if they actually want to.
Thank you very much, Sara. Does anybody want to add something to that? I just wanted maybe to give a quick note on commercial arbitration, because you did make a distinction to commercial arbitration and investment arbitration. Just to insist on the fact that confidentiality is sometimes necessary for business parties as well, right? And specifically in certain cases there are, I'm just taking an example here of gas pricing arbitration, for example, which is a very technical example, but maybe some of you are involved in those cases, or some energy related disputes where you want to keep certain aspects, for obvious reasons, confidential, right? And this is actually why some parties go to arbitration versus court sometimes, because of confidentiality. Well, in fact, you can also still, because there's been a call for transparency, and people are saying, oh, it's all behind closed doors, we don't know what's going on, but also because there was no precedent. So people are thinking, well, we don't even know how the arbitrators are deciding in one case or the other, so we can't rely on other cases. There's no, there's no material for us, so it would be good for us to have a publication of awards. Well, actually, the ICC and the LCIA and actually the majority of institutions are working towards publication of awards now, even in the commercial arbitration sector. One way of going around, the sensitive matters is just to black them out, or so you can keep the legal issues there and get rid of the contractual provision or something. So I just wanted to add that in terms of the commercial perspective also, is like people criticizing it actually don't understand maybe the sensitivities of it, and also that in fact there are ways to overcome that in the commercial sector. Yes, of course.
I mean, just a few points on the secret. This whole debate about these secret tribunals. Actually, this hysteria came with Chapter 11 arbitrations in NAFTA, and when America never lost a NAFTA case, so kind of you and cry quietened down. But also because transparency was introduced into the NAFTA treaty. And as Sarah's right, when you give people that option, they may not exercise it. But I think it's very important for people to have that option with investment arbitration, because the state's a respondent, and ultimately any payout's going to come from the budget, which is going to come out of your pockets if you happen to be a taxpayer. That's why it's important. And I think whether people click on it or not, that's the option you ought to have, and I think that's pretty much it, really. And I don't know if anyone else has any thoughts.
That's a good point. I just might add, I think in the future, I think we'll talk about this a little bit later, more ISDS claims are going to relate to issues like the environment, to climate change, human rights issues, and that is where it's critical to have transparency, because that really does affect the populations where that are bringing these claims. And so not just for the taxpayer dollar, but also the public health issues and the environment and climate. So I think transparency is a must, and I really hope that more states do sign up to the Mauritius Convention, because I think ISDS, first of all, should be transparent because it does involve issues of public interest. But secondly, I think it would take a lot of the stigmatism out of ISDS if it were open.
Yeah. If you have anything to add on that would be great on this topic. Yeah.
Interestingly, I think with regards to arbitration and this particular issue, we're always being in the situation with governments as well that we would want transparency, because there's the public to answer to, and then there's a lot of government ministries as well. But the issue also arises at what point in time the transparency actually happens. There's the negotiating phase, and then there's an arbitral award, and after the award, then there's settlements as well. So negotiating that. So the issue sometimes becomes with us as well, and with the public asking for information and us not being able to provide that as well is because putting things out in the public domain at one point in time is one thing, but then putting it in the middle of things when we know that it will possibly jeopardize what eventually the outcome needs to be, that's something that we need to balance for. But that being said, it's states are generally inclined towards disclosing as much information as they can without it being against the national interest.
Sorry, can I just add one?
Yeah, just a concluding point.
It's actually, I mean, I just wanted to sort of bring this up because you've got the Freedom of Access to Information Act, and I wonder whether people couldn't access that kind of information through that particular law. And I feel a lot of the to use your terminology, and I'm going to attribute that term to you, Sarah, Sadia, is fake news. I mean, if you actually, there's so much debate about the cases and the payout. If you actually just give it to the public, let them attend the exit hearing on YouTube. If why not? And arbitrators don't really care about the press. We don't read the newspapers that much. We never have time. Besides, we're not paid to read the newspapers. We don't read it.
Yes, please answer that.
So that's understandable, but like I think from the government's perspective, it's also like when you're going during an arbitration and there's stuff being disclosed, and I think it also matters from a case-to-case basis as well. In certain cases, I do agree that it's okay for the public to hear it, but in certain cases, when you possibly know what's going to come out in the arbitration, and it's going to impact public policy on a larger scale, or later on events that are going to happen, I think if there's a larger consensus within government bodies that it shouldn't be disclosed, the option should be there, because I think every arbitration doesn't impact just that particular part, or it's not just a one-off case. I think it has a larger impact on the country. So in the interest of the larger good,
just quickly, just on the act that Mahnaz had mentioned, sort of the catch with that act is that it has to be public information. So the prerequisite of that is that you can have access to that information, but it primarily relates to information that is on public record, and there's a lot of qualifications to that because we have other legislation which protects information. And I've seen cases where eventually the people who want to seek that information have not received it from the public officials, and then have again made recourse to the courts in writ petitions saying that this is our right, give us this information. So it gets more complicated, but just sort of to tackle that.
Thank you very much for this. This is very interesting. I mean, we could go on for an hour. Honestly, I have much more questions on that, especially Maham to you. But I think we'll move on. We'll move on to another topic, which is also very interesting. That comes up a lot. Is arbitration is not a place for women. And I know a lot of you think it's a provocative question, and this is why we're here in Arbitral Women to talk about it. But I hear that all the time and everywhere. So it's not just again, like I haven't worked here, but I imagine this comes up here a lot as well. So we're going to have a specific Pakistani perspective on this. But please believe me when I say that it comes. I've heard that everywhere. So please, Maria.
Sadia, I'm just going to say it's very difficult to limit my response to a certain time limit. I could go on with stories. So again, just from a Pakistani perspective, I think the issue of female representation, either in terms of legal counsel or in terms of women being appointed as arbitrators, goes back to the core issue of essentially women in law in Pakistan, and there haven't been enough representation of women, and that's because the profession is largely male dominated. It does relate back to there being patriarchy in society, and because there has been lots of difficulty of women getting to the legal profession and then maintaining their sort of work-life balance or the demands that the profession has of them, it eventually becomes difficult for them to enter into this specific field. So that's why it's an issue that is recurrent. And in terms of appointment as arbitrators, in the arbitrations that I've been involved in, the domestic ones, I haven't seen any female arbitrator, and that is also because the arbitrators who've been appointed are retired judges. We don't have a female judge in the Supreme Court of Pakistan. So who is going to retire? Yet, yes. But so that's why the people who you select, the pool is just females. But I also take the point that it's not an issue which is specific to Pakistan, and I believe that it is in 2015 that a pledge has been signed, which is the equal representation and arbitration pleadings, and both Addleshaw and 20 Essex chambers have signed on to that pledge, which sort of also raises the issue and reflects upon the point that, in fact, globally also, women are not represented. And I was reading up the statistics, and back in 2014, there was zero representation of women as arbitrators in most of the institutions. You're talking about the LCIA, the ICC, the Hong Kong institution, and even in 2017, even in the ICC and LCIA, it's 20% or less. And even in that situation, it's not party-appointed arbitrators. It's arbitrators who've been selected by the institutions, which also goes to what the perception of the parties is, and definitely not Pakistan specific. So that's sort of my take.
Maham, I would like to hear your perspective from the Attorney General, your experience at the Attorney General's office on that.
Thank you. So interestingly, I agree with what Maria says. In Pakistan, the issue is not with regards to women in arbitration, but it's a larger issue of women in law. That being said, I personally believe, and my experience has been, I went to law school in Pakistan, and half of my graduating batch were women, most of whom have gone on to do litigation both in local courts and internationally as well. At the Attorney General's office, interestingly, I'm the only woman in the International Disputes Unit, so gender balance is still an issue. But I also think that stems from a perception amongst women themselves that this particular field is not for them. I've spoken to a lot of people who are now graduating who believe that law is a male-dominated profession in itself, and then arbitration and international arbitration is a smaller niche. So to find their own place in such a niche would be even more difficult than finding their place in the larger sector. That being said, my experience at the Attorney General office has actually been quite pleasant and quite rewarding. Part of it also stems from the fact that I work with a group of young lawyers who are also now becoming engaged on the discourse of what women face at the workplace and are open to dialogue on that particular issue. One of the reasons I also think that some women are being held back by it because of their own perception. We receive very few applications from women. So when we're talking about why there's just one woman and the rest of them are men, it's at least for the AG's office, it's not because they don't want to hire women, it's because women don't apply, because firstly it's a government sector, and the perception that women working comfortably in the government sector is hard in Pakistan, which I think is also a myth now, because that's not the case, at least with the younger generation working. And again, men in our generation are open to the idea of the issues faced by women. I, for once, have had no issues in being assigned to cases like gender has not had a role to play. So I would take this opportunity to encourage women to apply and to become part of the discourse and to try to, I don't think that being a woman anymore is going to be a barrier to working in the government sector or in international arbitration in Pakistan, for sure.
So you know what to do. You need to go and see Maham and apply to the AG office. That's what you need to do. Aneesa, I'd be extremely interested in hearing your views as well as a partner in one of the major firms in Lahore, and especially considering the kind of work that you do. And in Pakistan, of course. But I just meant to say based in Lahore. Yeah, please give us your views.
I couldn't agree more with what Maria and Maham just said. But I would actually say that it's because the pool is, yes, you're correct, the pool is so hard to get into in terms of just litigation, but litigation is a very hostile place for women in Pakistan. So if you can get into litigation and be successful as a litigator in Pakistani courts, I think getting into arbitration would be the easy step in my opinion, just because the level and extent of misogyny and hostility that you face at a daily basis in the courts of Pakistan is. I mean, I don't want to.
No, but
I think that government departments are actually much better. So courts are much more hostile. I don't know if the other Pakistani lawyers agree with me on this.
I think I agree with you on that. I think international arbitration is a way more women-friendly place in
because you have these
particular than
pledges
going to
and
local courts.
institutional buy-in in terms of encouraging women. I mean, we haven't been able to do that at the judicial level. Like, I think it makes so much sense that there are judges who are not elected, so they don't have to be.
But I also think a larger reason why women don't come into international arbitration is in Pakistan. It's also because the lack of mentorship for women to come into international arbitration. So there's still men doing it, like there's Malik Khan and a couple of other people. But when you, as a woman, when you look up to someone and you say, I want to be an international lawyer in Pakistan, I can't think of any woman who's practicing in Pakistan on the top of my head. So there are people like Mahnaz you can reach out to who are outside Pakistan but get advice from. But from within Pakistan, I think our generation of women who want to do international law need to look outside Pakistan to get inspiration from. So I think that's something.
Yeah, I couldn't agree more.
When you don't have an example, so it's harder to then find your period there.
So the example of women practicing in arbitration outside of Pakistan, Sara and Mahnaz, do you think that investment arbitration is a friendlier place for women, and are there more place for women in investment arbitration, based on your experience?
Sadia, I'm going to answer that question. Can I be permitted an observation on the very interesting discussion and possibly a solution, really, which I'd like to canvass around the table? So, first of all, I'm very grateful to be here because I always feel that Pakistani lawyers are perhaps one of the most expensive lawyers in the world, and getting free legal advice from so many able people around this table and in this room is always a privilege. So I'm going to use this opportunity to canvass thoughts and hope to obtain some views really from you. The role of counsel and arbitrator meet but are different. So when I look for arbitrators, for me, honesty, fair-mindedness, openness, and above all, availability are key criteria. The role of counsel, of course, you need someone fairly aggressive. You want someone who is going to win your case. And this is where I think the slight opportunity perhaps lies in the disconnect. So if you look at the leading, what I call Premier League footballer type of Pakistani counsel, they just don't have the time. And they're making far too much money as counsel. And this is where perhaps the opportunity lies, where I think women who probably don't want the cut and thrust of the courts every day, bring in, and I'm not being, it applies equally to men who don't want that kind of lifestyle. The arbitrator role offers a very good alternative where you have someone quite settled, quite open-minded, who has time to listen to you in an open-minded and fair manner, and who has the capability. So actually, it's actually quite a nice role for people who don't want to go down that slightly hostile environments of the courts. Now, how do you change that? Because I feel a lot of arbitrator appointments come from you either know, you've seen in court, and therefore people want to appoint you, or they come from knowing, it's a boys' club at the end of the day. I know him, he's a good chap, I know he's going to do right. And let's face it, as women, we don't have that kind of social interaction. It is changing, but that's what it is. This is where the role of institutions is absolutely key, and that links in with Sadia's question. The institutions can change that role because they come in with a neutral sort of, it's not my mate that I'm going to appoint, it's somebody actually from a roster that's qualified and I can appoint, and therefore you can, look at both women and men. I'm not saying it's a pro-women bias, but at least you have that opportunity. So you've got two solutions on the table, and of course with a change in mindset coming from the next generation, I think that would be great. Sadia, I'm conscious I've used up my time, but just very quickly on your point. The world of investment arbitration is a bit like the UK judiciary. There are hardly any women. We were very lucky to have Lady Hale give a landmark judgment, it is what it is. It shouldn't matter. I don't think your gender should matter when it comes to decision making. You're not fighting a duel as a gladiator in ancient Rome. So the fact that you're a man or woman, I think, shouldn't really matter because strength is not an issue. But it does, because you've got the figures in front of you. I mean, if you take out 2 women that are appointed routinely in ICSID arbitrations, I think it's 3% of all women. And Sadia, thank you so much for introducing me in the way that I think would have brought tears to my mother's eyes had she been here. But really, it is no mean feat to be the youngest woman in ICSID arbitration. What, there are 18 women? Come on. And with, I'm very privileged to hold that position, but really, given the dearth of women in investment arbitration, and as you correctly mentioned, it is what it is. Now, how are we going to find solutions to those challenges? And I think that's the discussion, perhaps, that we need to focus on, in the coffee break and beyond.
Yes, Sarah.
Please, yes.
Just to add one point on this, I look out into this room and I see young, hungry, bright lawyers. And one thing, we're talking about particular gender diversity, but there's also the issue for me of geographic diversity and age diversity. And I really want to stress the last one, age diversity. Now in my appointments of arbitrators on ICSID tribunals and otherwise, I almost never choose an older arbitrator, the pale stale male, because they don't have time. I have been before some of the most preeminent arbitrators who have not read my clients' briefs, and I find that appalling. And they don't read them because they're not hungry, they have loads of appointments, they don't have the time, they don't need the money, they just are appointed over and over and over. So I think as counsel, we need to be braver in our choice of appointments. I don't care if it's male, it's female, I want somebody younger, who is going to read everything, who is going to ensure that my client is, the case is heard, that those arguments that we're making are considered. So I think we have to be a bit more brave and not just go with the easy, he gets appointed all the time, of course he's a safe pair of hands. A lot of times he's not, because he's actually not someone who has the time to dedicate to your client's issues. As a young arbitrator who, I've started recently taking arbitration appointments, I am hungry. So you want, as young arbitrators, they will read everything. They will issue decisions immediately. I get something from the parties, I issue something that day or the next day. It's just so much more quick and efficient. And so I think, it's not about really gender, it's about, appointing somebody with time. I also think as counsel, I'm from the American background, and so we don't have the solicitor or barrister dichotomy. And what I often do in my cases is I will give younger associates opportunities to have advocacy experience before tribunals. I think tribunals like to hear from different people. It breaks it up for them. So, to have the same person talk for 4 hours in an opening is a little bit monotone, and it's not as great. And arbitrators also like to hear from younger people. They like to hear from new advocates. And that's also a way that young lawyers can get known before these tribunals and think, oh, actually, this is a pretty exciting. I was talking to I forget his name yesterday, and he was so excited about the new enforcement proceedings in Pakistan and how there's been some really great decisions on enforcement, and the enthusiasm that echoed through his voice as he talked about how things are changing. That's who I want to hear from as an arbitrator. It's that enthusiasm and that hunger and that excitement that we're just not getting in this older generation. So I would say, give your younger associates opportunities to advocate. As counsel, be braver in who you choose. Don't just choose the same old people. They don't have time, and they're, frankly, not as impressive as one would think in many circumstances. And then also the institutions. And I wouldn't mind hearing from, CIICA on because I think institutions is really where it's at. A lot of times we're constrained as counsel because ultimately the client wants a safe pair of hands. But institutions have more leverage to appoint people who are new and who are smart and who will be very hungry for the cases that they represent. And perhaps it's also an issue of applying to institutions. When I talk to the LCIA, for example, they say, well, you know what? Not many women apply. So we're dying to appoint women, we're dying to appoint younger arbitrators, we're dying to appoint different ethnicities and people from different geographic backgrounds, but guess who applies the most? Your typical, older, male, white individuals. They put their hands up. Does anybody else? So maybe, Rana?
Yeah, you raised a good point. I was about to comment. So you mentioned DAS at CIR. We were thinking of launching a service like that. So I'm not too proud to admit this, but at this point we just have 2 women on our panel of arbitrators. One is Malaysian, one is Pakistani. But of course that needs to change. But I think part of the problem is that a lot of them don't apply. The applications we get are predominantly from men. But on your point about diversity, I had a chat with Mark Cantor, who's a famous American arbitrator based out of Washington, D.C. And he said the same thing, is that you cannot count on parties to nominate young people or women or people from different background as arbitrators. It's always institutions. So of course he mentioned ICC, CIICA. So I think that makes perfect sense, and that is where I suppose CIICA can play a pivotal role as well.
Yeah, exactly. If I may just to close up on that point, because we talked a lot about the issue that exists, and I think it exists in Pakistan, it exists everywhere, and it exists in investment arbitration, it exists in commercial arbitration. There are clear solutions. I mean, Sara gave some very practical advice, and it's true. I think there is an enormous role to play from counsel in selecting their arbitrators. I mean, also in my experience, my clients, they completely trust you, right? They trust your judgment. I mean, you're handling the case. I mean, what do they know about arbitrators, right? You have the knowledge, you have the industry-specific knowledge. So yes, of course, we sit down with a list for them. But if in the list there are absolutely no women, then it's on you. It's on you. If there are no young arbitrators, it's on you. If you're not going to say what Sara said, as saying this guy is going to sleep in the hearing room, he's going to sleep, he's not available, and he might die during the. And that happens.
It happens.
That happens. That has
and it's
happened.
Expensive when it happens.
Yeah, it happens, and I've seen that happen. So it's not, you need to hear those things. So solutions, what has been going on? Because I think it's important to end on a positive note. You have mentioned the stats of ICC, LCIA. There are a lot of stats of these institutions, but also a lot of institutions. I have seen, and I witnessed, and I think Mahnaz, Sara, I'm sure you agree with what's going on our side of the world. There's been so much discussion going on in the past years, so much pressure coming on from everyone, all parties involved, that the institutions, exactly for the reasons you mentioned, Sajjad, have stepped up and made a huge change in appointing women as arbitrators and younger generation as arbitrators, and you can see the evolution in the stats. So of course it's still like 25%, 20%, but it's from 5-0 to in several years, right? So this is a huge increase of women arbitrators. That's one thing. And even in investment arbitration, of course, you always see these 2 names as the top, nominated, and I think you're very humble in mentioning that it's no big deal that you're the youngest woman, and it is still. I still think, seeing, I'm sure that people seeing Mahnaz will be like, yeah, I can be Mahnaz. Why not? It's not special. Why not me? Right? So the point, and get yourself on the rosters of institutions, and yes, the CIICA. There's so many others, right? They're looking for arbitrators to be appointed. The third thing is, I think, and I'm just going to close on that, there are different parties involved here. So we mentioned institutions, we mentioned you guys as counsel, right? But there's also, and I don't know if there's some in-house people in the room, in-house people here. Are there some third-party funders? Is that something that is developed in Pakistan at all or not? Just a quick word on those. So in investment arbitration especially, we have third-party funders, banks essentially, that come in the scene and finance cases as well, right? So, they are they have an increasing, role in the world of arbitration, because they're the ones bringing the money or is going to finance your case before arbitration. Why am I mentioning them? Well, first of all, because they actually have a role to play now, even in this field. And I'm just going to give you a practical example of, and don't want to make any publicity for anyone specifically, but I just think it's important because there's been an equity project that was launched by one of those third-party funders where they have a pool of money, so $50 million, specifically for projects that are initiated and led by women counsel, so women lawyers, or women in-house people, which is huge. It's a practical thing. It's like we have money for projects that are led by women. So lead those projects, right? The second thing is in-house lawyers. I had an experience where we were pitching for one of the biggest oil and gas French companies. I'm sure you know which one. And we went there, and as you know, there were 6 key partners of the office. We went there to pitch for an hour-and-a-half interview across departments. I was there as well, and it was an interview from 14 women. Okay, and they were all lead positions in the litigation team, and we had to talk about of course their expertise in different fields, but also like what are you doing in terms of diversity. And they said, we're really embarrassed when we get a pitch and you propose a team and you have no women on the team. Like, it doesn't reflect well. So because that came from them, and now, I mean, of course, our firm, values that a lot, but now they're like, oh no, we really need to like put women more in charge. So if everyone plays their role, it will change, and I have seen it has changed. So that's just a positive note on that. I'm very conscious that we are well above our time, so maybe one last point we can discuss, which I think is very interesting for all of us, and especially you, is one of the myths that we hear in Pakistan is that, and we've talked a little bit about it already, is enforcement of awards in Pakistan. If you get an award in Pakistan, it's never going to be enforced. If you cede your arbitration in Pakistan, it's never going to get enforced. So Aneesa, could you talk on this, please?
Yes, in fact, I remember at the last conference that CIICA hosted, the Young ICA conference at the Lahore High Court in 2017, one of the critiques was this, that, arbitration is great, but at the end of the day, you have to bring your award back to Pakistan and enforce it here. I don't know if it's just coincidence, but in the 2 years that have followed, 2 judgments have come out from the Lahore High Court enforcing foreign arbitral awards. So you had a 2-part question. The domestic award situation is different. So seated in Pakistan, I think it would be along the lines of what Maria mentioned. But for foreign arbitral awards, they automatically come under the 2011 Act, which is the recognition and enforcement of foreign arbitral awards and arbitration agreements Act 2011. So that was passed in 2011. However, in 2012, we had the CIICA judgment, which came out from the Lahore High Court, which now wrongly relied on the Hitachi versus Rupali Supreme Court case to not enforce the award, and they interpreted, they didn't look at the seat of arbitration, they just looked at if the award was governed by Pakistani law, that automatically made it a domestic arbitral award. What that means is, in terms of court procedures, that means you can go to the civil court under the 1940 Act, and the judgment holder would want to go to the High Court, again, because of the perception of how the proceedings are at the civil court and at the High Court. So CIICA essentially said that both courts have concurrent jurisdiction, even when it comes to a foreign arbitral award. So there was a lot of confusion, because at the end of the day, despite the clear wording of the 2011 Act, foreign arbitral awards were being treated the same way as domestic awards. However, we had the conference at the Lahore High Court arranged by CIICA, and that in 2018, a judgment was authored by Shahid Karim, Justice Shahid Karim, who incidentally was also the keynote speaker at the LUMS workshop that we met at. And that enforced a foreign arbitral award under the 2011 Act. However, that judgment doesn't address the CIICA case at all, and the issue of concurrent jurisdiction between the civil court and the High Court. That has now finally been resolved in The judgment that came out last month, authored by the divisional bench of the Lahore High Court. Justice Aisha Malik wrote the main judgment, in which overruling CIICA, the 2012 judgment, and definitively laying down the law that a foreign arbitral award is a foreign arbitral award and shall come under the 2011 Act and enforced as a foreign arbitral award. And thereby, and she distinguished the Hitachi versus Rupali case by saying that the Hitachi versus Rupali case relied on the 1937 Act, was interpreting the law under the 1937 Arbitration Act, which has been repealed by the 2011 Act, which was something that could have just been done at the stage of CIICA in 2012. However, now there is no confusion because that case has now been overruled.
I really like ending on positive notes, so I think this is a very positive development for Pakistan. I can go through my list of other myths and discussion that we had that are equally as interesting and especially in investment arbitration, but unfortunately I do realize that their lunch is here, so I don't want to keep you from eating, A, and 2, we have another set of a very interesting program in the afternoon, which is the training workshop. So I think even if my questions, and I'm going to say them, because we can talk about them during lunch, and I welcome you to join all our panelists to have the discussion. One of the other myths that we had was investment arbitration is biased against states, so it's pro-investor. Another one was, BITs, the signature of bilateral investment treaties increases foreign direct investment. And there were additional ones, but I think another one which was interesting was the confusion between the World Bank and the ICSID. So their relationship that the World Bank, or the role that the World Bank has to play investor arbitration. You have the experts here to discuss these questions and many more over lunch, so please do so. But before doing that, please give them a very big round of applause.